SJC-10725, Commonwealth versus Bois.
Good morning, Mr. Shedd. When you get a chance, when you get ready, we're all set.
Good morning. I think I'm ready. My name is Dennis Shedd, and I'm representing Ryan Bois. Mr. Bois was convicted of the rape and murder of his young cousin and other crimes after a trial at which he presented an insanity defense. And the defense was based on evidence that he'd been in several psychiatric hospitals when he was a teenager, expert testimony about the general relationship between criminal responsibility and mental illness, and the nature of the crime and his behavior afterward. And friends had dropped him off after a party, and within an hour, he'd committed a brutal crime against a child he adored for no apparent reason. A friend who saw him afterwards said he did not seem to be in his right mind, and the arresting officers described him as ranting and raving. Now, in the closing argument, the prosecutor used two themes to suggest that Mr. Bois was not insane. And for the first two-thirds of the argument, the theme was, this is the criminal mind at work. 6 times he repeated that, stretching the evidence beyond the breaking point to suggest that Bois was behaving rationally that night. He suggested he was hospitalized not because he was mentally ill, but because he was acting out or because he had a drug problem. He suggested he had gone to his grandmother's house, not because he needed a place to sleep that night, but with the intent to steal money, that Joanna caught him, so he murdered her, that afterward he went to the 7-Eleven to establish an alibi, and that when he was caught, he considered using the knife to stab the dog to escape, but then decided, no, I'm going to do it, go with the insanity defense. None of those inferences can be reasonably drawn from the evidence in this case.
Was there any evidence of malingering?
No, I don't think there's any evidence of malingering, no, none at all. And just to give a couple of examples there, the Commonwealth justifies the reasons for the hospitalization being something other than mental illness, being drawn from the grandmother's testimony. That under direct examination at one point she said, I've known him all his life, I wasn't aware that he was mentally ill. But then she goes on to say, I knew he was in psychiatric hospitals, I knew they put him on medications, he was on medication when he came out. I know that from a very early age, things that didn't bother other children seemed to bother him, and he would act out violently, not only towards others, he would hurt himself as well. As to the suggestion that he might have intended to use the knife against the dog, the officer who released the dog watched as this incident unfold. He never reported that he saw Mr. Bois attempt to stab the dog, and in fact, he reported that Bois was pleading with him to take the dog off. Now, in the final third of the argument, the theme changes, and at this point it becomes, a monster came into the life of Joanna Mullen, and the monster looked like this. This is what the monster did to her. 14 times he referred to Mr. Bois as a monster at the close of that argument. And in wartime, people often refer to the enemy by insulting names. In World War II, you saw things about Japs and Krauts. And the purpose of that is to dehumanize them. And that's exactly what was happening here. He's suggesting this is not a human being who might be suffering from mental illness. This is a beast operating with the mind of a beast. Now, these statements all went straight to the heart of this case, the insanity defense. In this case, where the jury deliberated for 7 hours over the course of 2 days and asked a question about the insanity defense, the improper closing argument warrants a new trial. Now, on the next issue, counsel violated her duty to conduct a reasonable investigation.
Excuse me, what was the question about? What was the jury's question about?
They asked whether the insanity defense would require a finding of insanity for all the crimes or whether they could evaluate that individually for each crime. That's what that question was. Going back, so counsel failed to reasonably investigate his history of mental illness and to present evidence that would have strongly supported the insanity and diminished capacity defenses. She was aware that he'd been in psychiatric hospitals and that they had diagnosed him with serious mental illnesses, but she never got copies of his records. None of his records were in her file. She did retain Dr. Ebert, and she was aware that he had gotten copies of their records, but there's no evidence that she looked at the records that he had obtained, and Dr. Ebert never offered her any advice as to whether the records might have benefited the defense at trial. Now, given what she knew about the records, a conscious decision not to review them would have been unreasonable, and without reviewing the records...
Say that she made a conscious decision not to review them, or that...
No, she didn't say. I'm just suggesting...
She doesn't remember whether
she doesn't remember. She said she doesn't remember one way or the other.
So you're saying there was a conscious decision
No,
on her
I'm not.
part?
I'm saying if there were a conscious decision, that would have been unreasonable.
But we can't determine that on this
Right,
record.
I agree. You can't, I'm just suggesting if there she doesn't remember one way or the other. Dr. Ebert said he reviewed his files and his memory, there's no indication that she ever went to review his records. That's what the evidence is. And without reviewing the records, she was in no position to make a decision as to whether to use them at trial. And these records would have provided a substantial benefit to the defense. The jury was told that a history of mental illness is an important factor in evaluating criminal responsibility.
Excuse me, do we have these records?
Yes.
Okay, we
Yes.
have the records, and so I understand that they're a mixed bag.
That's what the Commonwealth's position is.
And that's what the judge's position
What?
was, too. The judge's position on the motion for
Right.
new trial.
Right, yeah. I'm going to talk about what those records have. And there are two things. The judge and the Commonwealth say they'd be more harmful than helpful because they have evidence of misconduct. And so the jury hears the history of mental illness is an important factor, but they never hear that he's ever been diagnosed with a mental illness. That left the door open for the prosecutors.
I assume they heard he'd been admitted to hospitals.
Right.
Because of his conduct.
They heard that he was...
Grandmother testified.
They heard that he
and
was admitted to hospitals,
extensively,
that's
yeah.
right. But there's never any testimony that he was ever diagnosed by those hospitals as having a mental illness, which left the door open for the prosecutor's argument that, well, he may have been admitted for some other reason unrelated to mental illness. If the records had been introduced, they could not have made that argument. Those records show that from age 11 until he aged out of DOIS at 18.
How old was he at the time of the murders? The murder?
He was 20 years old. So at 18, he aged out of DOIS, and he's 20 years old
So
when
the
this
last
incident happened.
the last record would have been concerning how he was at
When he was
the age of
18, that's right.
So nothing about how he'd been in the 2 years prior.
That's right. That's right.
And that record would have said what at 18?
At that point, he was still diagnosed with mood disorder, NOS, and PTSD, and he was undergoing counseling. I believe at that point, he was not on medication, but he had ongoing counseling, and those two diagnoses were still in effect at that point. So had those records been introduced, the prosecutor couldn't have made that argument. The jury would have heard he'd been diagnosed over the years with PTSD, bipolar disorder, and other mood disorders.
I take it one of the things that was not produced, maybe I'm wrong, I'm trying to remember, at the motion for a new trial was any evidence from any expert that, in fact, he was not criminally responsible.
That's right.
There was no evidence of that, and indeed, defense counsel had retained an expert who said, I've looked at all the records, I can't say that.
There was no testimony at trial other than Dr. DiCataldo's general testimony about the relationship between criminal
Right, but I mean, at the motion for a new trial, there was no new expert to come in and say, if I had looked at all these records, I could have testified that.
No, on the motion for new trial, we were never suggesting that counsel made a mistake by not presenting an expert to testify that he was he was not criminally responsible. She retained Dr. Ebert. He was unable to offer an opinion. The suggestion is only that she should have introduced the records of his past history of mental illness. And had those records been introduced, again, that could have been tied into Dr. DiCataldo's testimony that mood disorders in other cases have been led to findings of lack of criminal responsibility. Now, getting back to the other point, yes, the records do have information about past misconduct. Now, certainly information in the records not relevant to diagnosis or treatment would have to be redacted. But assuming that prior bad act evidence would come in, it's completely consistent with the defense in this case. Those records show that he'd been hospitalized after engaging in violent act, and the hospitals then diagnosed him with serious mental illnesses. That's exactly what he's arguing happened here, that this violent act was the product of a mental illness. Now, the Commonwealth has also suggested that counsel may have decided not to use the records to avoid reciprocal discovery obligations, but that really boils down to exactly the same issue. If you look at the records on balance, do you think they're going to be more harmful or helpful to the defense? Without reviewing the records, counsel was in no position to make that judgment.
We don't know whether she didn't review them. But we don't know that she didn't review them.
Well, I believe in the combination of her lack of memory and Dr. Ebert's finding that he had no records and no memory of her reviewing them. I think we could, and the judge, in fact, I believe, found in her findings that she had not reviewed the records. I may be mistaken, but I think that was included as part of her findings. But I think from those two things together, you can infer that
Really
she
sort
did
of a
not
lack of
review the
evidence
records.
rather than evidence, right?
Huh?
It's almost a lack of evidence that she didn't review them.
You could view it that way, I guess. I mean, he has no memory and no records of it. I mean, if his lack of records of her going to visit is a lack of evidence, I suppose you could view it that way.
And she offered no record into evidence from those records.
I'm sorry, I don't.
Defense counsel did not offer into evidence any of the records of his medical history. Or did she?
No, there were no, you mean at trial?
Yeah, at trial.
No, at trial, there were no records introduced at all of his medical history, medical or psychiatric
No,
history.
and no
There's nothing.
discussion with regard to reciprocal discovery or any of that stuff
No.
that would have been triggered had she pondered the use of those records.
No, there was nothing at trial about that, no.
And the problem you have, to be blunt, is even if you get past the idea that she should have looked at the records, in the absence of any expert opining that he was without criminal responsibility, it's still a very tough road to hoe, isn't it?
Well, Blaisdell is very clear that an insanity defense can be based on behavior at the time and a history of mental illness, and that records of that history can be introduced without expert testimony. And that's what, I mean, she certainly did present the defense without an expert opining about the criminal responsibility, but Blaisdell also allows that next step. And that's the step I think was missing here, and the fact that it was missing allowed the prosecutor to make their argument that he may have been in these hospitals for completely different reasons. And these records would have shut that door right down and shown the jury.
Had he been in the hospital for some different reasons as well? Or was it all just mental illness, not substance abuse, not anything else?
I believe, well, he was sent to the hospitals after engaging in behavior that the schools he was at the time found very disturbing, and they admitted him to the hospitals and found him to have these mental illnesses and put him on medication and counseling for it. So I think he was sent there because of they believed he was mentally ill. They believed he was mentally ill.
He had several stays at places.
He was in about 7 different psychiatric hospitals and spent months and months in the hospitals.
And some of that evidence actually came in through the grandmother who...
She testified that he'd been in hospitals, right, and that she had visited him there. That's right. That's right. That's right.
But at the time of the killing, he was employed. Was he
I
not?
don't know. I don't believe that's true.
There was evidence that he had been employed.
No, there's a record saying that towards the end of his time in DYS at age 8, when he was still 17 years old, at that point, he had a job. There's no evidence that he had a job at the time of this
I
incident.
thought the grandmother had said he had a girlfriend, he had a job, he was getting his life together.
Right now, I don't recall
I could
that.
be
I
wrong.
just don't recall that right now. I'm sorry. A new trial should also be granted because the judge took no action after receiving reliable reports that a juror had been sleeping. In this case, the reports came from at least one other juror, a court officer, and a colleague of trial counsel's. And even if you were to question the reliability of the report from the alternate juror, there was certainly no reason to question the reliability of the other reports. Now,
But they may have been observing the same thing, which is what the judge observed as she watched the juror, which is that she closed her eyes. By the way, I close my eyes all the time when I'm trying to listen carefully. She closed her eyes, but she did not appear at all to be sleeping. I mean, so the judge actually watched and said, yes, she does close her eyes, but I don't find any evidence that she's sleeping.
Well, the judge said she was watching her during the instructions, but then the
Right,
initial reports come after the closing arguments. And at that point,
And counsel said, I didn't see, we were watching the jury during closing arguments. We didn't see any evidence of sleeping.
well, certainly the judge said that the court officer had reported this happening several times, takes water for her to drink to try and wake her up. And a colleague of counsel's noticed it during trial. This is before the closing arguments, but during the course of the evidence. So the reports of this juror sleeping during evidence, possibly during closing arguments, and certainly the judge says, I was watching, I didn't think she was during the instructions.
And the
but still
complaint went
earlier
further. She was sleeping during the instructions, but the judge was watching her very carefully during instructions and saw, yes, she closes her eyes.
Yes, but there's other issues about whether it happened earlier and whether these other reports
There's snoring
are reliable.
involved? I don't think there was snoring involved in this case, was there? Snoring involved in this case?
No reports of snoring that I'm aware of. No reports of snoring that I'm aware of.
And trial counsel, experienced defense counsel, basically didn't want anything done about this juror.
Yes, but
And that is quite unlike the most recent case where defense counsel did want something done.
that's right. But it's
And-
not
and it's not the case that this is something that we've decided can't be waived.
Well, I don't think a trial counsel's lack of a request for action can waive a defendant's right to an attentive jury. And
But
this court, I don't
she
believe is.
affirmatively said she didn't want anything done. It's not like she was not paying attention. She affirmatively said she didn't want the juror removed.
Right, when the judge offered to make her an alternate, that's right.
And the defense attorney said no. She was more worried about the one who was turning her in.
Right, that's right. But again,
That's somehow tactical and strategic and deliberate, and what's the judge to do in the face of the defense lawyer saying, I don't want her removed?
I think if the judge has reliable reports of a sleeping juror, I think the judge is required to take some action, a voir dire or some other remedial action. And I don't think a defense attorney saying, I don't want you to do anything, without at least consulting with the defendant. There's no evidence that happened here in the record. This all happens at the sidebar. That can waive the defendant's rights. And the appeals court has dealt with similar situations. The closest one to this, if I can just find my note here, I believe it's the Dias case. And I believe there the judge offered to, similar to this, offered to take some action, and the defendant objects. It's actually the same thing here, offered to make the juror an alternate. Defendant objects. And the appeals court went ahead and reversed and granted a new trial because the attorney's decision not to take action cannot be enough to waive a defendant's right to an alert jury, a jury that's heard all the evidence and the arguments. And without taking some action here after receiving reliable reports after the closing arguments, again, even if you question the later report by the alternate, those 3 reports from at least 3 people after the closing arguments warranted some kind of action, and nothing was done here. Now, turning to
3 reports after
the closing arguments before the instructions. Those are the ones from a juror sitting next to her, which may or may not be the same juror as reported after the instructions. The court officer and a colleague of counsel's had all reported at that point.
So you're saying that if a defense counsel, I'm not saying these necessarily the facts of this case, but if a defense counsel identifies juror number 4 as a juror who appears through body language to be extraordinarily favorable to the defendant, and somebody says, I think that juror number 4 was asleep for some part of it, and the defense counsel says, no, that's not true. I really do not want any inquiry of this person. I don't want that done. There's a new trial done, even though the defense counsel vehemently said, I don't want this juror removed?
I think the defense counsel would at least be obligated to consult with the defendant before that could qualify as a waiver of the defendant's right to an attentive jury. I think just the defense counsel saying it without consulting with the defendant should not be enough to waive the defendant's right. Okay.
You've got a minute.
I've got minimal time left. I don't think I really have as much time as I'd like to address the following question, the other issues. I will just note that One of the issues concerns a felony murder instruction. I would note just that last month, the court in Commonwealth de Tejada questioned whether it should join those who abolished or redefined felony murder. And for the reasons stated in the brief, I believe the court should at least abolish the inherently dangerous
But
felony
it
doctrine.
wouldn't, if we did that, it wouldn't help you here, since he was found guilty of premeditation, extreme atrocity, and cruelty.
He was not found guilty
Okay,
of
so
premeditation.
extreme atrocity and cruelty.
Yes, but there's a related issue with the extreme atrocity, which is the lack of diminished capacity instruction with regard to the knowledge for third-pronged malice. So that could have impacted the extreme atrocity. This could affect the felony murder. The two in combination would warrant a new trial.
He was not found guilty of premeditated murder?
No, he was not.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this Court to affirm the convictions, including the conviction for murder and rape and kidnapping of 6-year-old Joanna Mullen.
The felony, what was the underlying felony in the felony
There were two, Your
murder?
Honor. There were the rape of a child with force and the armed home invasion.
Okay, so is it clear which of those the jury elected, or
They
just?
elected both, Your Honor.
They elected
checked
both.
both boxes on the verdict slip. Your Honors, if I could start with the presentation of the mental health defense. The record is full of strategic information about counsel's choice as to how to present the mental health defense, the insanity defense. As the defense states, they never claimed that the defense counsel made a mistake in not presenting an expert about criminal responsibility. Suggest here defense counsel's strategic decisions prevented the Commonwealth from presenting an expert. Counsel very strategically did not file a Rule 14 notice, indicating that counsel would be relying on a testimony from lay witnesses and from a witness, an expert who had never met or reviewed the defendant's records. That's Dr. DiCataldo. Your Honors, and yesterday I did discover a transcript that wasn't with the court, and I did transmit it to the clerk yesterday, February 24th, 2009, where the Commonwealth is requesting a copy of a report, and defense counsel says, well, you don't get it because I didn't file a Rule 14 notice. I suggest that perhaps the Commonwealth was entitled to a Rule 14 notice, perhaps the Commonwealth was entitled to more information than it got, but as this case was framed and as it went forward, counsel's strategic decisions are clear. Counsel could not just put these records into evidence without disclosing them to the Commonwealth in advance. I suggest that that would be unfair.
But how could defense counsel evaluate the merits and demerits of doing that without having seen what the records say?
Your Honor, defense counsel had, first of all, the retained expert, Dr. Ebert, had reviewed the records. This is not a case where the records were not reviewed. Defense counsel had the Bridgewater report, the competency report, which identified various sources of information, and the report of the Bridgewater evaluator in there. Defense counsel had been present at, I believe it was arraignment or a day or so after the defendant had been arrested and was present for an interview with a clinician there. I suggest that defense counsel had ample evidence as to what those records were likely to contain. Again, there was no evidentiary hearing in this case. I don't believe there was a need for one, but had there been one, we might have found out something about the discussions counsel might have had with Dr. Ebert.
So there was nothing, there's nothing in the motion, there was not an evidentiary hearing on the motion for new trial?
There was not, Your Honor. We did have the affidavit of counsel and the affidavit of Dr. Ebert. Counsel says, I don't recall if I looked at the records, and counsel also said I didn't recall meeting with the defendant right at the time of his arraignment, but my notes say that I did do that. The judge did find that counsel didn't review the records, so we do have a little bit of a perhaps inconsistencies in the records, but I suggest even if we say counsel didn't review the records and should have, there's no ineffective assistance here. Review of those records shows that they would not have been of assistance to the defendant. They might have established mental illness, but they wouldn't have established a failure to substantially conform to the law or to appreciate the law.
If the defendant intended to submit the medical records, would the defendant have had to have given notice under Rule 14 of an insanity defense?
I believe he would have, Your Honor.
Why?
Because it would be producing records relevant, putting his mental state at issue. These are records that would ordinarily be reviewed by an expert.
And were there expert opinions contained within those medical records?
Arguably,
On the
Your
issue
Honor.
of mental illness?
There were people offering opinions about what ailments the defendant might have had.
You
So,
mean like ingrown toenails? What do you mean ailments?
bipolar disorder, post-traumatic stress disorder, other types of information relevant to his mental state. So I suggest that had the defendant intended to produce these records at trial, he would have been required to file a Rule 14 notice. But even if that's not the case, if he was going to produce these records at trial, he's certainly required to tell the Commonwealth ahead of time. I suggest that just showing up at trial with a box of records that the Commonwealth had never seen and had no knowledge of would be fundamentally unfair and would certainly violate the spirit of the rules of evidence and Rule 14. Your Honor, in those records...
I'm sorry, are you saying that if it's a she, by the way, I'm sure, the defense counsel?
Yes.
Beverly Canone, if she had reviewed those records and ultimately, before she had made a decision as to whether or not to admit any of them, you say that her review of them would have triggered a Rule 14?
Not her review of them, but had she intended to use these records at trial, that would have triggered Rule 14's reciprocal discovery requirements. And so certainly here, the record suggests strategic decisions made by counsel with consultation with a qualified, highly qualified expert who she'd worked with before as to how she was going to proceed in this case.
But Mr. Shedd's point is that she can't make that strategic call that the cost of triggering the Commonwealth response to a Rule 14 exceeds the benefits of offering it without having looked at the records.
Well, Your Honor, I suggest she could have based on what she knew, but even if that is the case, looking at the records, which the court does now have, they were produced in the course of the motion for new trial, the records don't particularly help the defendant. Certainly, I believe one of the justices referred to the information about the defendant having a girlfriend and a job. That I don't believe came in through the testimony of the grandmother. I don't believe that was in front of the jury at all. I think that was the note in one of the records that showed that on the cusp of adulthood, the defendant was making plans, had a job, doing the types of things people ordinarily do when they're becoming young adults. So certainly that type of information, the positive information in the records, wasn't going to be helpful to show that he was insane or not criminally responsible at the time of the murder. Again, the negative information, I also suggest that would have also come in, that the defendant wouldn't be able to just go through these records, historical records. There were no evaluations in there of him after the crimes were committed. These were purely historical records, and I suggest everything in there did go to his mental state. That was why it was there. His crimes, the difficulties he was encountering in school, and all of this other sort of information. Certainly a limiting instruction would have been appropriate, but the defendant wouldn't get to just pick what was beneficial to a lack of criminal responsibility defense and secrete everything else.
Can I shift just for a second? Why the use of this word monster 14 times? Have we decided a case recently on the use of the word monster in closing arguments?
The court did recently decide a case. I'm sorry the name escapes me. I believe I might have sent it to the court in a 16L letter. I believe in that case the court said that the jury would have been able to take it with a grain of salt. In this case, I suggest that it was fair. It was a fair use. In opening, defense counsel had said to the jury, he's sick or mentally ill, he's not a monster. In closing, the prosecutor's theme was the criminal mind at work, and then he did describe the monster in the night. I suggest that it actually was very analogous to the facts here, where a young
Were there
girl...
objections?
There was an objection to this, there was.
Just once?
At the close of the argument, there was
Okay.
an objection.
All of this monster talk.
Did the judge do anything about it at all?
The judge did not give a specific instruction about this. She did instruct jurors that closing arguments were not evidence and not to decide the case on sympathy or emotion. She made that instruction was in the context of gruesome photographs that were sent to the jury. Your Honors, in this case...
So you're saying it's okay for a prosecutor to call somebody a monster, a piece of dirt, to all these dehumanizing names is appropriate in closing argument?
Your Honor, I'm suggesting that in the case before this court here, the use of this term It couldn't have added anything to the evidence before the jury.
Which, of course, invites the question of why a prosecutor with so powerful a case would risk it by invoking the idea of a monster in the night, the boogeyman.
Your Honor, this case, again, it did occur at night. It was a young girl who was staying at her grandmother's home. The defendant broke into the house. It paralleled.
It's a
There's no
it's a
question
terrible
the crime
crime.
is monstrous. The question is whether the use of the word monster 14 times in a closing argument by a prosecutor is inappropriate. It dehumanizes the defendant in a way that's not relevant.
Your Honor, in this case, the defendant sought to use the very monstrosity of his crimes to suggest he was not criminally responsible. So certainly here, perhaps it was ill-advised, but certainly here, I suggest it could not have impacted the jury. The jury would have recognized this as a rhetorical flourish. So, Your Honors, I suggest that certainly there's no...
Well, the whole point would be to just make it impossible to look at this defendant as somebody who has an illness.
I'm sorry, Your Honor?
You couldn't really, I mean, it's to tilt the jury away from looking at the defendant as having an illness.
Your Honor, the Commonwealth was arguing that the defendant did not have an illness.
Right, but to call him a monster means it's, I mean, and in the nature of the crime, I mean, it didn't take much for a jury to feel quite sympathetic.
And this was in Cadet, and that was in response to an opening that was suggested in defense counsel's argument,
Yes, there are
inviting
some-
them to think of him, that he wasn't the monster, and, and using a lot of terms that suggested a counter-argument that was responded to by the Commonwealth in that case.
Your Honor, I suggest again, in this case, it wasn't something that would have impacted the jury's verdict. Again, counsel for the defendant was arguing that this is so horrible, he must be criminally insane. The prosecutor was arguing for a different conclusion. The other inferences the prosecutor asked jurors to make, I suggest that those were all based in the evidence. Certainly we have how did the defendant and the victim come into contact. I suggest where the crime occurred in a separate bedroom in the house, that it was fair to ask the jurors to infer that the victim caught him in the house, that she had been up and about.
Approximately how many times did defense counsel use the term monstrosity or words to that effect? Do you know?
I don't know.
Was
Your
it
Honor.
more than like 2 or 3 times?
I don't recall, Your Honor. I know she specifically used the word monster in her opening and in closing. I don't recall how many times she may have used that word, or if she used it at all, but she did argue that what had happened here, she called the crimes unspeakable, and how do you talk about this is what defense counsel said. So certainly I suggest that she was arguing that these were monstrous crimes that had been committed. Your Honors, the other suggested inferences, again, in the closing, certainly the victim catching the defendant, and I guess the only other possible inference is that he went and snatched her from her bed. I'm not sure that would be...
Wasn't blood found in 2 rooms? Or-
Yes, Your Honor, there was some blood found on a pillow in the bedroom where the children were sleeping, and there was blood found on, I think, a TV.
So what's
clicker.
the, I didn't understand how you could get the inference that the child had somehow caught him in the act.
That the child had found him in the house, other
Yeah,
than
but I
in the
mean,
bedroom.
how would you get blood in 2 rooms then?
It wasn't explained, Your Honor, at trial. It's not clear exactly whose blood that is. If the defendant, maybe he went into those rooms where the victim's brother was sleeping and where the grandmother was sleeping, and it got there somehow as a transfer, or perhaps it was there had it been there a while, someone had a hangnail. It's not known, Your Honor.
Did they know where the blanket came from in which she was wrapped? Was that in the evidence?
Pattern is the bedroom, as the sheets, the bedding in the room that where the assault occurred.
Which is where she was sleeping or not where she was sleeping?
No, she was sleeping in a room with her brother.
So the attack didn't happen there?
I'm sorry, Your Honor?
Where did the attack happen? In the room where her brother was?
No, in a different room.
In a different room?
Yes.
So what evidence would allow the prosecutor to argue that she had surprised the defendant or had caught him?
No, the brother didn't wake up. The grandmother didn't wake up. Nobody woke up to anything other than when the police called to ask the grandmother to check on the victim. I suggest had something happened in one of those rooms that they would have woken up. So I suggest it is fair to assume that
But she wasn't raped there.
She was raped in the other room.
Other room, and is there any evidence any reason to suggest that people wouldn't have heard that, or would have heard that? I mean, this is such an attenuated inference.
Your Honor, well, people didn't hear it, or at least nobody woke up. So I suggest that he was strangling her at one point. There was evidence of that. The defendant suggests that she wouldn't have been alarmed by his presence there because she liked him, and he was strangling her, so she wouldn't have been able to sound any alarm. But certainly I suggest that it was a reasonable inference in the circumstance, and certainly couldn't have harmed the defendant. I suggest that it really was supported by the evidence here. Again, the defendant's appearance at the 7-Eleven, in terms of making an alibi, the defendant's friends dropped him off at the grandmother's house. They didn't see him go in. They saw him walking up to the door. The evidence showed that he supported an inference that he cut the screen and got into the house that way, where they didn't see him go into the house. Had he gotten away from the police and not been captured while driving, drawing the attention of the police while speeding in the car, he may have disposed of the victim's body, as he told his friend. He had asked his friend about how he would dispose of a body. He may have returned the grandmother's car, and again, he may have explained, if his friend said, we dropped him off at the house, oh, I didn't go in, I went to the 7-Eleven, and known that there was a video of him there. So I suggest that that was also a reasonable inference for the prosecutor to ask the jury to draw.
If I can turn you to a rather obscure piece of Judge Sanders' decision, which concerns the home invasion count. I know that the judge said she made an error in her instructions by telling the jury that his possession of a knife was inherently dangerous, and that was an error. But she says there was sufficient evidence of that because he used it to open the screen and arguably to threaten the child. But the jury didn't have to, I mean, I understand that may be sufficient, but the jury didn't have to accept that. And so isn't there still prejudice from the fact that the jury never had to determine whether or not that was indeed their understanding of the use of the knife?
Your Honor, I believe the court's asking the cutting of the screen, was that sufficient use of the knife?
No, I understand it may be sufficient, arguably. If the issue is, was the evidence sufficient, I get that. If the question is, was there prejudice to the defendant from having an instruction that took that issue away from the jury is not, the fact that a reasonable jury may accept something to be proven does not mean that the jury necessarily would have. And is there not prejudice because the jury never made a finding of whether or not the knife was used in the way you suggest because the judge took it away from them?
Your Honor, I do not believe there was an objection to this, so I believe we'd be looking at substantial likelihood, and I suggest no in this case, again, where there was sufficient evidence of it being used to get into the house.
What the actual armed assault in the dwelling, what happened to that charge, armed home invasion?
That was a guilty finding, Your Honor.
Right, but it was also one of the underlying 2 felonies in the felony murder.
Yes, Your Honor.
So I just can't recall. Was he sentenced on the armed home invasion in some concurrent fashion?
I believe it was concurrent, Your Honor. I'm not, I apologize, it's escaping me right now.
It's really of no consequence in a way.
I thought armed home invasion and rape were concurrent life sentences, I thought.
I believe so, Your Honor, and again,
And everything else was filed, like kidnapping, larceny of motor vehicle, larceny over 250, and the other, driving to endanger, all the other.
If the underlying, but if the maybe this is just too arcane, but if it's a felony murder, what happens to the underlying felony?
Well, Your Honor, he was also convicted on a theory of extreme cruelty and atrocity.
Right.
So
Okay.
I don't
So
think
the underlying felonies, both underlying felonies would stay in any event as independent convictions.
I believe so, Your Honor. I
Okay.
don't think
I
they've
think
merged
that's
for
right.
sentencing purposes because of the conviction on the
Extreme atrocity.
extreme atrocity. Your Honor, with respect to the sleeping juror issue, It was the trial counsel, defense counsel, who actually made the observations of the juror. Trial counsel said to the judge, "I carefully watched this juror during the court's lengthy charge," and there was some discussion about the charge being 2 hours long or something like that. And she said that the juror might have closed her eyes, but she was confident that this juror was indeed awake. And certainly that's going to be entitled to something here, that there was an observation, again, by a highly experienced defense attorney,
But
not some...
let's just parse it a little bit. Was the issue raised before the jury instructions? When did the issue come up? It may have come up more than once. When did it come up?
It came up after closings.
After
I believe-
closings.
After closings or before closings. It was around
Okay.
that point in time where the judge said, I believe it was after closings, this was brought to my attention. One of the jurors says, the jury in seat number 12 has been sleeping. And there's a discussion of that, and then there's closing arguments. And then I believe it's the next day that the note is sent in. And defense counsel says, "I carefully watched this juror during the closing arguments, and I'm confident that
I
this
thought
juror..."
the judge also found that she had watched the juror during her instructions. Am I wrong about that? No, maybe I am.
You may be correct, Your Honor. I just don't recall that. But I do recall trial counsel for the defendant
Okay.
carefully watching the juror.
Okay,
See that
thank
my
you.
time is up. Thank you, Your Honors.
We'll take our morning break.